Hi everyone, this is Matt with Learn About Law, and in this video I'm going to discuss voluntary termination of parental rights and adoption in Wisconsin. What are parental rights in Wisconsin? Parental rights are quite significant in Wisconsin. If no legal father has been designated, either automatically through marriage or by adjudication of an unwed father's paternity, the mother of a child is entitled to full custody and decision-making authority. In the situation where a father has been adjudicated their status of paternity by a court or automatically designated the father through marriage at the time of birth, Wisconsin conveys on them an important set of rights. A father has the right to be considered first for custody in the event of the mother of a child decides to put them up for adoption. In addition, fathers have a right to bring a petition for a court to make a decision regarding custody of their child. Being the father of a child also entitles a father to submit a parenting plan as part of a court proceeding regarding custody of their child, conveying their desire for the child's living situation. How do I terminate parental rights in Wisconsin? Wisconsin law does allow an individual to ask a court to voluntarily terminate their parental rights. There are several procedural requirements to this process. The parent in question must present a petition to the court requesting a voluntary termination of parental rights. The court will only grant voluntary termination if they believe the parent who is relinquishing their rights fully understands all of the implications of doing so. The most straightforward way to accomplish this is a court hearing in which the parents in question will be subject to a series of questions by the presiding judge. The point of this questioning is to prove the parent fully comprehends the consequences of ending their parental rights and is competent to make such a decision. Should the parent in question prove to be mentally unsound, the court will be unwilling to grant their request. If, for some reason, an in-person court hearing is not possible, the parent seeking to relinquish their parental rights may submit their consent to termination in writing. Even though both parents are potentially consenting to the termination of parental rights, you may be surprised to learn that voluntary termination of parental rights is not routinely granted in Wisconsin. This is because, regardless of the intentions of the parents, when a Wisconsin court is considering an issue that affects the disposition of a child, they must apply the standard of the best interest of the child. This is a decision a court must come to independently, and while they can consider the wishes of the parents, they must always be put in the context of the child's best interest. The court will consider the stability of the child's life following termination, and whether any family members are willing to care for the child in their parents' absence. As part of this process, the court will likely appoint a guardian ad litem. This is an attorney who acts on behalf of the court as their investigator, gathering information through interviews with the parents and with the child to try to gain an understanding of the situation. They will then prepare a report they present to the court, advising them on what they believe to be in the best interest of the child, given what they have discovered. Wisconsin law strongly prefers that a child have two parents. This is to provide added stability, both in terms of the child's mental well-being as well as their financial well-being. If the court believes a parent to be terminating their parental rights purely as a strategy to avoid paying out child support payments, they will be unlikely to grant the request. Courts will also likely refuse in situations where a child losing their parent will mean they are likely to require public assistance. However, Wisconsin law only allows a maximum of two legal parents for a child. This means that if someone is seeking to adopt the child, voluntary termination is far more likely to be granted, as this creates space for the willing incoming parent and potentially avoids the financial adversary faced by a child losing their parent. How do I adopt my spouse's child in Wisconsin? The Wisconsin Department of Children and Families refers to this type of arrangement as step-parent adoption and has a process in place to facilitate this. Note Wisconsin statute allows a spouse to adopt a child when they live with both the child and the parent with custody, so you must technically live with the child to qualify for this process. There are 4 steps to step-parent adoption in Wisconsin. First, termination of parental rights in the event the child already has 2 legal parents. This is a necessary step as Wisconsin law allows a maximum of 2 legal parents for each child. Termination of parental rights can come about in 3 ways. 1. The parent voluntarily terminates their rights, covered above in greater detail. This is a difficult process, but can be aided if a step-parent is willing to adopt a child. Second, the parent's rights are involuntarily terminated by a court after proceeding in which the court determines this action would be in the child's best interest. This process is covered in more detail later, but note that courts are very often reluctant to grant such an order. Third, parental rights are automatically terminated when a parent passes away. The second step in the step-parent adoption process is submitting a petition to adopt and order for investigation to a circuit court with jurisdiction over the child. This step officially begins the process of adoption by formally requesting the court to consider your request and initiates the court procedure. After the petition is submitted, the third step of the step-parent adoption will be an investigation into the child's potential living situation by the adoption agency. This is ultimately followed by a hearing on adoption, which is a decision that will be reached. Thank you for watching.